first call upon Mr. Rajendra Kumar, who's a paper presenter, who's going to be speaking on intermediate reliability. Please come up on stage. May then call upon the panelists who are part of the round table. It's Pranesh Prakash, Professor Vivekanandan, and Shavik Badro. Is Mr. Badro here? Okay. Okay, so all of you have the brochures in which all of these gentlemen have been introduced rather well. I mean, all of them are very distinguished leaders and thought leaders in their own fields within the broader spectrum of intellectual property. So Mr. Rajendra Prasad is a leading IP counsel and litigator, working as a partner at KNS Partners in Delhi, and well known for his work, particularly in geographical indications and some others. He also has a book, a leading treatise on geographical indications, published with Lata Nair from the same firm. And he's been a big supporter of the academic activities. I can say that one of the few law firms that have gone out of the way to support academic endeavors year after year. So anytime that we've approached him for any sort of support, they've, without blinking an eyelid, they've always come out and support and have participated in these activities, lent a lot of insight, particularly from a practitioner perspective, because often in universities people accuse us of speaking in the air, not knowing what the ground realities are. So we try and get some of the ground realities through inputs from leaders of the bar, such as Mr. Prasad. So we're very thankful that he's here. Pranesh Prakash is a leading civil society activist and again a thought leader in his space. He does a lot of work around IP and technology. He's with the Center for Internet and Society. He's also an Internet Fellow. Is that correct? Okay. It's a very, very prestigious, I think only a couple of people every year get this fellowship, and Pranesh was just nominated. So he does a lot of policy work, not just in India, but abroad as well, mainly around access to knowledge, access to technology, intellectual property, etc. Professor Vivekanandan is the intellectual property, the MSRD chair at NALSAR in Hyderabad. And I've been very privileged to know him for some years. He's again a pioneer in this field and he's one of the only Indians or few Indians on the Internet Governance Board of ICANN, right? And he's playing a very critical role there in terms of how ICANN is reshaping itself and how countries are playing a role in reshaping ICANN in terms of internet governance. He's doing a lot of work around that. He runs a project called Giga also at NALSAR. He's also the head of the LII India project, which I think is quite a significant project for India, because what it seeks to do is really to democratize law and bring it, make it much more accessible for the common man. So what LII, and I would encourage all of you to look at the website. It's Legal Information Institute of India, LII, and they started off in Australia. They have called OSLI, and then they have something in Britain called BAILI, B-A-I-L-I. Many of you may have come across it while you're researching, because BAILI will give you full access to case law. You don't need to go to any proprietary database. You just go to BAILI and you get all the British case law, fully authentic. And Vivek is replicating for India in the form of, is it INDLI or IndiaLI? Or India LII?
LII of India.
LII of India, I'm sorry. There. Because I knew there was a difference in the way that they approach it for India. So it's LII of India, and the goal is, and we're also helping from the Eastern region, and several other institutions are part of it, but the goal is to put out at least basic law in an accessible format in just one electronic space in a website. So you can go there, whatever laws you need, state laws, central laws, case laws, basic laws that the common man needs ready access to. It's all going to be available soon.
It's touched 1 million case laws.
It's touched 1 million case laws. Just for India? Okay, fantastic. So terrific progress there. So a lot of pioneering work that he's been part of. We have Shavik Badro, who I'm particularly happy he's here with us today because, not least of which is because he's an alum of NUJS, and he's a very young but a partner, leading partner at one of the most dynamic law firms that we have in India today called PXP Partners. And we called Shouvik at very late notice, and he very willingly obliged to come in and partake in this panel because he does a fair amount of IP work in his law firm. And they've got a bunch of very, very young, dynamic leaders and thinkers at their law firm. So we'll hope to hear some good insights from him as well. So with that, may I please invite Mr. Kumar then to present his paper, which is liability, and then we'll sort of open up the panel. And in the interest of time, we're not going to have 2 sessions. We're just clubbing into one, and I'll moderate this session. So can I please invite? Yeah, sure. Can I invite Pranesh to say a few words on the TPM, because what we have 2 distinct dimensions to this panel that they're going to deal with. Although it's widely worded as copyright and technology, there are 2 specific points or themes that we're going to hop on. One which will be dealt by Mr. Anand Kumar is the question of intermediary liability, which is a hugely contentious issue, and there are 2 specific provisions dealing with that in Section 51. And then we have TPM, technology protection measures, which Pranesh will deal with very, very briefly. So since it's loaded up, I think we can continue. Okay, Pranesh, why don't you go ahead and say a few words on TPM? Just lay down the broad sort of framework so we have...
Okay, I'll just make some very, very brief comments about TPMs. For those who don't know, TPMs are sort of digital lock. They're also known as digital rights management, or DRM, and you might have heard that term. TPM is what it's called in the WIPO Copyright Treaty, and we, as India, are not signatories to the WIPO Copyright Treaty or to the WPPT, yet we have voluntarily chosen, for reasons that I do not understand, to go in for compliance with the WIPO Copyright Treaty, which means and includes having provisions on TPMs within our law, and also includes, for instance, extending the term for photographs for life of the photographer plus 60 years, rather than just the 60 years that currently exists. This is quite unfortunate. But there's much to be praised about the way we have gotten in for TPMs. I would unreservedly say that currently it is possibly the best system for TPMs that exists anywhere in the world. There is still scope for improvement, which I'll touch upon very briefly a bit later. So the good thing is that while the best thing about the current provision on TPM is that it's very narrowly tailored to fit on top of the copyright system. This it does through 2 provisions. One, saying that nothing that is not the subject of copyright can be the subject of TPM. Okay. Secondly, it also states that everything that is an exception to copyright will also be an exception for TPMs. These 2 are very important because and show that certain kinds of lessons have been learned from the fiasco that was Section 12.1 of the DMCA, where various kinds of things that weren't covered by copyright were still being covered by technological protection measures, by these digital locks, and just breaking these digital locks in and of itself became a crime. So that's the good part of it. Now, the one other really good part is manufacturing, selling, distributing, advertising, etc., which are covered by various other laws, including the relatively progressive New Zealand law on this matter, is not disallowed in India. So that's really good. While manufacturing, etc., is allowed, but facilitating circumvention is regulated with a record-keeping requirement. The good part of that is it's not prohibited, and there is no penalty, express penalty provided for not having this, for not maintaining these records. Second thing is it doesn't, as I mentioned, it does not target circumvention tools. It targets the act of circumvention. The negative points of our law is that it does not place a duty on the TPM placer or the copyright owner to extend facilities for circumvention when the user is unable to circumvent on his or her own. So what this basically means is that it gives you a right, in essence, to break a lock. But if you don't have the tools to break the lock, then that right is of no use, right? And for certain advanced encryption methods, and TPM is basically based on cryptography and based on encryption. For the more advanced things protected under TPM, right now there aren't any freely available, openly known ways of breaking them. So that means you have a right, nominal right in the law, but you don't have any actual ability to make use of that right. A provision to this regard is available in the Spanish law on TPMs. One negative point is that it's a criminal wrong, not just a civil wrong. This is not required under WCT. Under the WCT, making it a civil wrong is sufficient. The bright side of this, of course, is that mens rea is required and proof must be beyond reasonable doubt because it has penal provisions. Thirdly, the phrase facilitating circumvention is not clear. What exactly will trigger this process of keeping records as to who you're helping? It can be read widely, it can be read narrowly. I personally think that it should be read narrowly in order to make it practicable. So it can't be, for instance, that everyone who puts out on their website, say for instance, Linux software, like any Linux OS that has the ability to play DVDs, for instance, automatically has in it a small blob of software that circumvents DCSS. Now, if that is taken to be, so if the producer of that Linux operating system is taken to be facilitating circumvention, then you need to keep a record of every single person who's downloading Linux of any kind of network. And I download my copy of Linux off peer-to-peer network. So will those kinds of records have to be kept? So in order to make it practical, I think we have to necessarily have a very narrow reading of what facilitating circumvention means. And I'd just like to end it there. I'm sure we'll get time to come back to this in greater detail later.